Okay. All right. Ms. Rivers, we're going to get on the record in State versus Joyner. It's 25 SC 005 515. Ms. Joyner is here with Ms. Rios, and we have Ms. Nix for the state. Ms. Joyner, Ms. Rios asked that we add your case to this morning's ad hoc calendar because you were prepared to enter a plea. Is that correct?
Yes.
Okay. The way this will work is that in just a moment, Ms. Nix is going to put you under oath, and then she's going to ask you a bunch of questions. They're going to be very similar to the questions you heard Ms. Smith ask Mr. Mitchell, but they're your questions, and we need your answers truthfully and completely. I also need you to let me or Ms. Rios know if you have questions of your own. Will you do that?
Yes.
Okay, great. Ms. Nix.
Thank you, Judge. Ms. Joyner, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Barbara Joyner.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
36.
How far have you gone in school?
12th grade.
Did you graduate or you made it into 12th?
Made it into 12th.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offenses?
Yes.
Count 1, aggravated battery. Count 2, aggravated stalking. Count 3, stalking. And count 4, willful obstruction of law enforcement officers.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Ms. Joyner, do you remember having been arrested on these charges?
I'm sorry, could you repeat that?
Do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you're entering a somewhat non-negotiated plea and the state may recommend a sentence to the court without your having agreed to it in advance?
Yes.
Are you aware that the state's offer is 10 years that you serve 30 days with the balance on probation? You have 24 days of credit, and the state will recommend that the remaining 6 days be served on the weekends.
Yes.
With the special condition of a permanent no contact with Heather Webb.
Yes.
Have you discussed this offer with your attorney?
Yes.
Judge, I believe that her final plea was when I was in trial, so I'm not sure if she still has her final plea rights.
What do you remember about that?
She does because you were in trial. I don't think we had an offer even at that time.
Okay.
Okay. So what that means, Ms. Joyner, we're not trying to use code. Ms. Rios is going to advocate for a slightly different sentence because I heard this was a somewhat non-negotiated plea. So Ms. Rios is going to argue for something different. If the sentence that I impose is more severe than what Ms. Rios says, so longer probation, if she says no jail time and I include jail time, she says no fine and I include a fine, anything that makes the sentence more severe would mean that you and Ms. Rios could talk about the sentence that I impose, and then you could let me know, sorry, Judge, I was willing to take what Ms. Rios said, but not what you did. And so I'd like to withdraw my plea. And you'll be absolutely free to do that today and today only. After today, if you want to enter a plea, you're stuck with whatever sentence you get. But today you'll have a chance to think about what I impose. If it's different from what Ms. Rios said, if I agree with her and say the same thing, I'm not going to ask you, what do you think about that? Because I gave you what your lawyer asked for. And it sounds like there's a small difference between the two. I have a hunch what it is. But I'll hear from Ms. Rios about that. And if it's a different sentence that I impose, I'll give the two of you and Ms. Rios, a chance to talk about it.
Okay.
So what I just listed was the offer as to count 2. As to count 1, the state will reduce to battery and offer and recommend a sentence of 12 months probation, and state will now process counts 3 and 4. Do you understand that's the state's recommended sentence?
Yes.
So the one felony would be aggravated stalking, and that's the basically 10 years to serve 1 month. And then count 1 misdemeanor, now battery, and 3 and 4 dismissed.
Yes, sir.
Thank you.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from what your lawyer might ask for as a sentence, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
I'm sorry. Could you repeat that?
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Guilty under effort.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Yes, speak up.
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes.
How do you plead to the charges of battery and aggravated stalking in indictment number 25 SC 005515?
Guilty under effort.
Is this Alfred plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal as outlined in OCGA 5-6-35 within 30 days of today?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for the felony, you have only 4 years from today, and for the misdemeanor, you have only 12 months from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about March 15th, 2024, the defendant came to Heather Webb's home located at 657 Boulevard in Atlanta, which is in Fulton County, in violation of a temporary protective order, which prevented her from having contact with Miss Webb and coming to her residence, and struck her several times, causing visible bodily injury, including bruising and a black eye. Miss Joyner was still on scene. She was in the parking lot of the apartment when officers arrived and did state to law enforcement that she knew she wasn't supposed to be there. And this occurred in Fulton County.
the battery that you're reducing aggravated battery to, is that just plain old battery, or because of the nature of the relationship between Ms. Joyner and Ms. Webb, would it be a family violence battery?
It would not be family violence battery.
Okay. I want to make sure that the final disposition reflects that.
Judge, Ms. Webb is on the Zoom and would like to make a statement.
Great. That was my next question, was whether Ms. Webb wanted to do that. Good morning, Ms. Webb.
Good morning.
So I'm going to add you to the screen here. I'm Judge McBurney. It's nice to meet you. I am here to listen to you about how this incident has impacted you, what you think ought to happen, anything you want to share about this situation.
I can't see you. I can hear you, but I can't see you.
Well, I'm there. I don't usually have.
Okay, no problem.
I'm here. I can see you. That's the important part, and the court reporter can as well.
Okay, thank you. Well, I have wrote a victim statement, and first I want to say thank you for allowing me to stand before you today, not just as a victim of crime, but as a woman who has endured prolonged harassment, threats, and trauma. And yes, I am a little emotional because, yeah, this was a lot. At the hands of the defendant, for several years, I was subjected to stalking, harassment, and escalating acts of violence, which was began as unwanted contact that turned into a pattern of disturbing behavior that made me feel unsafe for my life. On the evening of March 15th, all of my fears came true. I was completely violated in my home. I lived in constant anxiety, never knowing where or when the next encounter would occur. My sense of peace, security, and normalcy was taken from me. The final assault was not just attack on me, but a threat for my life. I was physically beaten and kicked at my right eye, and kicked where I had just recently undergone a kidney transplant. I was completely afraid for my life. I could have lost my life, not only lost my life, but lost my eye to this this incident. My body was in a vulnerable state, but critically to my life and survival. This was deliberate, target, and dangerous. Your Honor, I can hear the defendant saying, while she kicked and beat me, excuse my French, die slow, ho, over and over again, as I begged the defendant to get off of me and stop kicking me. Even with the TPO in place, the defendant on more than one case has still made it her business to violate the TPO and constantly harass and stalk me.